Good afternoon, and welcome to Legal Update Live. I'm Tom Larson, and I'm the President and CEO for the Wisconsin Realtors Association. Today, we're going to update you on the federal antitrust lawsuits involving the National Association of Realtors and many brokerages around the country. So now we want to just give you a little bit of background on the Sitzer versus NAR lawsuit and verdict. As many of you know, this was a class action lawsuit filed by a group of sellers against the National Association of Realtors and a number of national brokerages. The issue at hand was the National Association's buyer-broker commission rule, often referred to as the cooperative compensation rule. Prior to the jury trial, two of the national brokerages entered into a settlement agreement with the plaintiffs. Those two brokerages settled for a combined $138 million. Another one of the national companies that was named as a defendant settled after the jury trial in February of 2024 for $70 million. The jury came back with a verdict after only 2 hours of deliberations, and came in with a verdict with an estimated damages of approximately $178 billion. Now, that verdict was automatically tripled under federal antitrust rules. So that amount was approximately $5.4 billion when all was said and done. Now, the actual verdict has not been finalized yet. There is post-trial briefing underway in which both parties are making arguments to the trial judge to possibly reconsider the verdict, possibly reconsider the amount awarded by the jury, and the final judgment is not expected until April or May. Now, there are at least five things that are notable from this case. The first is that the judge in this case was handpicked by the plaintiff's attorney. There was a reason why they picked to file that case in the Western District of Missouri. The judge in this case was a former plaintiff's attorney in the area of antitrust and was considered to have the most favorable viewpoint for plaintiffs in this area of the law. One thing worth noting is that the Court of Appeals in this case, the 8th District Federal Court of Appeals, is made up of largely defendant attorneys or former defendant attorneys. They are considered probably the most favorable Court of Appeals to look at issues from a defendant's perspective. So you have an interesting contrast here between a federal circuit court judge that looks at the world from a plaintiff's lens, and then a Court of Appeals that looks at it from a more of a defendant's perspective. And that's important, especially when I talk about the second key notable from this case, is that the judge in this case applied what's called the per se rule. And the per se rule is a rule of evidence that is applied when to take a look at what the plaintiff's burden of proof is when proving their case. The other rule of evidence is what's called the rule of reason standard. The per se rule is a very draconian standard, and it's rarely applied. And the reason is that once that rule is applied, there is no way to demonstrate any justification for that rule or policy. The judge in this case determined that the NAR's rule was so anti-competitive that there cannot be any justifiable benefit to the consumer. So the court made that determination, and the only thing that was left up to the jury was whether or not there was an agreement between NAR and the national brokerages. That's why that verdict took such a short a period of time for the jury, is because the judge made that determination that NAR's rule on its face violated antitrust, and there was nothing that NAR or the defendants could demonstrate to show that it did not have the anti-competitive effects that the judge determined. The other thing worth noting is that only two defendants remain in this lawsuit, NAR and Berkshire Hathaway. The other national brokerages have all settled. Again, two before the jury's verdict and one after that. This is important because there's a big question about the appeal and whether NAR has the resources to be able to even file the appeal. One of the rules in a class action antitrust lawsuit is that in order to appeal, you have to put up a bond equal to the jury's verdict. So in this case, it would be a bond of equal to $1.78 billion in assets, or possibly $5.34 billion. And looking at NAR's financial sheets, they don't have the $1.78 billion in assets. Now, because each of the defendants is jointly and severally liable, together they may have it, but even looking at Berkshire Hathaway's home services, together, NAR and Berkshire Hathaway probably don't have that much in combined assets to be able to put up the bond necessary. Now, the judge can lower that amount in order for the appeal to move forward. And that's one of the things that is pending before a final order is issued. And that brings me to the last point. As I mentioned earlier, the judge will issue the final order sometime in April and May. In addition to the jury's award and possibly the amount that's required to put up for bonding, there is the potential that the final order could consider possible rule changes for NAR. Right now, the jury's verdict only applies to monetary damages. It doesn't make any changes to NAR's rule or the broker compensation rule. So that's one thing that is in the judge's power that may be in the final order. So watch for this. And these are things that we're all looking for in the next several months. Now, NAR is planning to appeal this ruling if the judge doesn't make a 180 or some major changes in its ruling. But the chances are NAR is going to appeal this. And their primary argument on appeal was that the judge made a fundamental mistake by applying this per se rule versus the rule of reason. And I explained to you how draconian that per se rule is. And it just makes it extremely difficult for any defendant to overcome that determination, because really all that's left is whether or not there was some agreement between the parties. And NAR feels that that's one of their strongest arguments on appeal. And in hearing a number of different antitrust experts speak on this, they all agree that the determination by the judge that this was a per se case was extremely rare. And everybody kind of raises an eyebrow that that per se rule shouldn't maybe have been applied. And I think that's why you see so many copycat lawsuits being filed around the country, is because this per se rule makes the burden of proof on the plaintiff so very low. And Jennifer is going to talk about the copycat lawsuits in the future, or very soon. But I think that's really, the fundamental reason why NAR feels it has a good chance of winning. In addition, they feel that the plaintiffs in this case, this pool of sellers that joined the class action lawsuit, did not have standing because they didn't purchase anything directly from the defendants. They didn't even demonstrate that the national brokerages that were named as defendants actually were involved in the transaction. They didn't have to prove any of that. They just named all of the national defendants with the deepest pockets and said, we're going to name you all, and we figure that some of you must have been involved in these transactions. So NAR thinks that that's a fatal flaw as well. In addition, they feel that the plaintiffs did not meet their burden of proof, even under the rule of reason standard, for demonstrating that there was a conspiracy. that they never showed that there was a formal agreement between NAR and any of the other defendants. And they felt that without at least demonstrating that there was no formal agreement, that you couldn't show that there was a conspiracy. Now, NAR has a number of other legal arguments as well. Everything from the judge made an error in jury instructions. They allowed testimony that they shouldn't have. But those first three are the big ones, and why NAR feels very confident in appealing this case. And the fact that the Court of Appeals for the 8th District, this 8th District Court of Appeals, is much more favorable for defendants than the circuit court judge. So I mentioned that to you only so that you know why NAR feels confident on their appeal. I'm going to now turn it over to Jennifer to talk more about some of the copycat lawsuits.
Good afternoon, everybody. I'm going to be talking a little bit about the copycat lawsuits and some actions by the Department of Justice recently as they relate to one lawsuit in particular, and then another agreement between NAR and the Department of Justice. As Tom mentioned, because of the way that that Burnett case or the Sitzer case came out, where the judge applied that per se rule, it opened the door up for all of these copycat lawsuits where other people were seeking to file claims and try to be successful on that same legal reasoning that was used in that case. There's been over 20 lawsuits that have been filed since the decision or the proposed decision came out. The most recent one was in the middle of February 2024. Various states, Missouri, Illinois, South Carolina, Texas, Georgia, Pennsylvania, California, there's a couple in Utah, there's a couple in some of these states actually, New York, Arizona, and so on. So all over the place, there's been these copycat lawsuits. Who are the defendants in these lawsuits? NAR has been named. State associations, MLSs, state and local brokerages, local associations, looking at who's been named in these various lawsuits. They're just going after anybody who's possibly where they think that they could be successful under that same legal reasoning that was used. Some are filed on behalf of local or state classes. Some are on behalf of nationwide classes. Class action lawsuits are a thing into themselves, actually. What you have to do is get a group of people similarly situated that can argue that they endured the same injury and then get them certified as a class to proceed forward. So that's typically how they've been operating, going after home sellers, going after home buyers to see if they can organize these people into a class. The challenges that they're waging are similar to the cooperative compensation rule plus other various activities where they're alleging that that cooperative compensation is somehow an antitrust violation because it restricts competitive actions among firms that are competing for business. So that's the copycat lawsuits. And, you know, like Tom said, that case laid the groundwork for what everyone expected was going to happen, which was these copycat lawsuits. One lawsuit in particular that I want to take a look at is one that was out in the eastern part of the United States. And the reason we're taking a look at this case is because the two sides in this situation had reached a settlement, a proposed settlement. This case, the defendant in this case was the MLS Property Information Network. So out again on East Coast, Rhode Island, New Hampshire area. And like I said, the two sides, plaintiffs and defendants, had come together and said, we think we've reached a settlement. Then the Department of Justice intervened and said, wait a minute, we don't think that the court should approve this settlement. And they had their reasonings, which I'm going to talk about in just a minute. But oftentimes when parties are willing to settle in a lawsuit, it's of their own volition. They're both agreeing that this is what they want to do to make the lawsuit go away. And now we have the Department of Justice stepping in and saying, not so fast. We don't think this settlement is beneficial for the parties in this case, particularly in this situation, the plaintiffs. And we'll talk about why they disagree in just a minute. The settlement was for $3 million. That's the settlement fund. Primarily, that's for attorney's fees. That was one of, not the main issue, but one of the issues that the DOJ raised in their petition or their statement of interest in the case. The parties also agreed to some rule changes in terms of being able to offer 0% compensation, alleging that reiterating that the buyer's offer or the buyer's firm's compensation is negotiable. That was one of the proposed changes in the settlement. There was also going to be a new rule requiring listing firms to check a box, basically certifying that they told the seller that the offer of compensation is not a requirement for the buyer's firm. So again, it looks like they were trying to maybe go for transparency in these proposed settlement terms. Like I mentioned before, buyer's firm compensation being negotiable, they can offer 0 in the offer of compensation. This settlement is pending court approval right now. So what they did was they said, we think we have an agreement, send it to the judge, and then that's when the DOJ stepped in. Part of their objections, this was very recent, February 15th of 2024 is when the DOJ filed their statement of interest in this case. Part of their arguments as to why this settlement should not be approved is because they say that the settlement preserves the core concern of sellers setting the buyer's firm compensation. They're saying that the proposed settlement of the listing firm being able to check a box saying, I told the seller that the offer of compensation was not a requirement, and having that statement in there, the buyer firm's commissions are negotiable. They're basically saying that that doesn't do enough, according to their opinion, stating there's no meaningful difference between offering 1 penny and 0 cents as the offer of compensation. They also pointed out that in this proposed settlement, there's a statement that the buyer's compensation is going to be negotiable in this proposed settlement. They're like, that was never an issue prior to that, so that doesn't really solve anything. It's solving a problem that wasn't really there to begin with. There's always been that negotiability with the buyer's firm's commission. They also cited a study from the state of Washington, I believe, is where they did the research, showing that even after MLSs out there changed their rules saying that firms could offer 0 cents or didn't have to offer an offer of compensation, period, that nothing meaningfully changed in that market. So they were citing that study as to why the court in this case should not approve this settlement. Interestingly, they also are advocating for an injunction that says sellers and listing firms should not make an offer of compensation at all to buyers' firms. They want to completely separate those two transactions so that buyers are paying the buyer's firm independently outside of any offer of compensation. And in fact, like I said, they want an injunction to prevent that offer of compensation being made. What is going to happen in this case? We don't know yet. The court can still approve the proposed settlements that the parties agreed to over the DOJ's basically objection in this situation. It's wait and see on this one and what effects this has for any other lawsuits that are pending. The last thing that I'm going to talk about is there was a proposed settlement between the National Association and the Department of Justice, where there were some concerns that were raised. So November 2020, NAR and DOJ entered into a settlement agreement about this issue. Some of the agreements or some of the provisions that were in that settlement agreement, you've already seen out there in practice, where buyers' firms cannot advertise that their services are free unless they're truly not getting money from anybody. That you can't have a practice where you steer people towards properties based on the offer of compensation. Those are just some of the big points that were part of that agreement. So November 2020, NAR and DOJ say, yep, we see face-to-face. Then July of 2021, DOJ withdrew from the settlement agreement, saying we no longer agree to those terms. NAR filed a lawsuit and said, listen, we had a deal. You agreed to this. It went to court, and the circuit court ruled in favor of NAR, saying, you folks agreed to this. You had this proposed settlement agreement, the final proposed settlement agreement. You can't now back away. The DOJ appealed that, and now that's where we are right now. Oral arguments were in December of 2023. They're online if you want to listen to them. They're not terribly long, but they're basically arguing about whether the DOJ has the legal authority to walk away from the settlement that they agreed to and kind of reopen the issue that previously, as of November 2020, the parties thought was a done deal. So that's another way in which the DOJ is playing into this landscape that we have right now. And with that, I think I'm going to turn it over to my colleague, Cori, and let her talk about why Wisconsin's different.
So we've talked about Sitzer, we've talked about copycat cases, and we've talked about the DOJ's, the Department of Justice, involvement in Wisconsin around all of this. So how does this apply in the state of Wisconsin? I see we have a few questions, and I think we're going to be able to respond to a number of them just through this part of the presentation. So when I say, and Jennifer does, and Tom, Wisconsin is different. It is different in so many wonderful ways. Real estate's different in a number of ways. And the way you practice real estate differs from state to state. And in Wisconsin, we are truly different. You have state-approved forms, those WB forms that you're required to use. The Real Estate Examining Board, the REB, approves those forms. And the REB and the Department of Safety and Professional Services, the DSPS, regulates your licensed practice. So we are different in that aspect by the fact that you have state-approved forms. Those forms include commission transparent and consumer-friendly language. It has for a number of years and will continue to do so. And when I mention that it's different, the reason that it's different is because in the state of Wisconsin, you have those state-approved forms, but you're the only state that we're aware of that has all state-approved forms. So some have disclosure documents that they're required to use, but a number of them have different realtor associations or MLS forms they use or forms created by attorneys. They might differ from 25 miles from one place to the other as to what form they have to use. In the state of Wisconsin, you're all required to use those WB forms if they're made available. Therefore, it does make it, we argue, a little bit less attractive for a plaintiff's attorney to come in to file a copycat lawsuit. And that's why so far we believe that we haven't seen one in the state of Wisconsin with the Wisconsin Realtors Association or any other of our firms. So Wisconsin has a strong consumer transparency in our WB listing and buyer agency agreements. As you know, you have blank lines when it comes to commission. Your listing contracts have compensation to others language where you actually talk to the seller about the compensation that's going to be paid and how it's going to be paid out to the other cooperating firm. You have buyer agency forms that have a discussion on the buyer's consent for buyer's agents to receive payment from seller or their agent. And when I mentioned that your language and your your listings and buyer agencies have been very consumer transparent for a long time, that is true. And in addition, in 2011, the compensation to others language was added to the WB listing contract, where you have that further transparent conversation about you pay me this as a listing firm and this is what we pay out to the other side. And in 2024, as you're well aware, the language in the forms was further enhanced to boost consumer transparency in your listing and buyer agency agreements. In addition, Wisconsin has a very strong buyer agency culture. A number of other states don't have this type of culture. You have a state law that requires you to have a written agreement. For example, in residential, a buyer agency agreement is your WB 36. If the buyer is going to be your client, if you want to have the buyer as your client, you must enter into that WB 36. Other states don't even have a buyer agency agreement. They actually will say the buyer is my client if I'm working with them. They have no disclosures that they add, no written documentation. And if they jump from me to Jennifer, they're then Jennifer's client because Jennifer's working with them. So it's very different from one state to another. In addition to the fact that we have all these strong consumer transparency elements to our buyer agency and other listing contracts, we do currently have a buyer agency work group that is meeting with the WRA to see if there's other conversations, other improvements that can further enhance consumer transparency. So we'll be working on that. One of the responses that a number of states have started to utilize throughout this conversation is mandating buyer agency. Some means that when they say buyer agency is going to be mandated means that you just have to have that written buyer agency agreement. In other states, it means that you can only have a buyer client if you're working in a transaction. So we're having that conversation. Again, we're even working on further education. So if you're interested in getting your ABR, you're going to be hearing more from the WRA as to education opportunities there. But really, what is WRA's response to litigation? Of course, we're going to continue to monitor the new and pending litigation, but we have not been idle. Your WRA legal team and the WRA itself, we've been preparing behind the scenes for the worst case scenario. While I mentioned that currently there is not a copycat lawsuit filed against the Wisconsin Realtors Association, we're preparing as though that's coming any moment. We don't want to be blindsided. We want you to know that we're here, that we've been working diligently and trying to make sure that we can go through all the steps. So since 2019, when the lawsuits were filed, we took initiative. We hired expert antitrust legal counsel. While you have some of the foremost experienced brokerage service attorneys working for you on your legal hotline in your legal department, we know where our limitations exist. We don't litigate antitrust cases on a daily basis or frankly ever. So this is one of those areas where we wanted to say, we know we need strength in numbers. Let's hire outside and get an experienced antitrust expert to help us. We worked with the Real Estate Examining Board, as you know, again, to boost the consumer transparency even further in those listing contracts and buyer agency agreements that you're required to use. And we do continue to educate you of the lawsuits and the DOJ's involvement. We will continue to create member resources which I'll highlight in just a moment. And we're going to continue to explore options and defenses behind the scenes. But we are here to tell you we are on offense. We are not on defense. We are being proactive, not reactive, as your Realtor Association. And we find that that's very important for you to know. And so we just wanted to kind of let you be updated a little bit about those steps. As far as what you do with consumers, we just want to reinforce some of the elements that we've already provided you. Please remind the sellers and buyers, there's not a standard commission percentage. The commission and the listing and buyer agency agreements, how do you kind of utilize those? How do you work with those? Discuss and explain those with your consumers, your clients. Avoid pre-printing commission amounts in your listing and your buyer agency commission lines. Do not suggest or portray the buyer's agents work for free, as Jennifer indicated. That was part of the conversation in the DOJ's discussion. And then in a compensation to others in the listing contract, make sure again that you're discussing and explaining. Avoid pre-printing compensation to others amount. So make sure that the seller understands that this is a conversation and not a directive. Also, one of the things that we wanted to highlight is if you're going to consider making changes in an addendum to the compensation language or compensation structure in your offers to purchase, we are strongly encouraging you to make sure that you're speaking to your private legal counsel as to what that looks like. Again, this is kind of if you're doing this now. As you know, we've indicated that we feel it's fairly strong that we are a state-approved form state. And so when you start working outside of that, we're unclear as to what that could mean. So that's why we're cautioning you about utilizing addenda at this moment to modify the compensation and commission language. And then don't steer buyers based on compensation offered. Again, those are things that we've been highlighting for you. I mentioned that we have some resources to help educate your consumers. We have WRA consumer brochures. They're online. They're available in PDF. We have a buyer agency explanation. We have an explanation of the residential listing contract. And then just most recently, we've created the Why Should a Buyer Choose Buyer Agency? It's a quick overview that supports that buyer agency consumer brochure. Again, just trying to educate the consumer from a third party so that you can kind of have that resource for them. And if you'd like, I've provided you the link there. And so that is kind of the elements that we wanted to highlight for you. In addition, we have a resource page where this video and other resources will be housed. So wra.org/antitrust. We continue to update that. That has WRA resources as well as NAR resources. Tom and Jennifer, that is all we have. If you saw any questions in the chat that you feel would be beneficial to quickly respond to.
I just had one quick one. Somebody's asking if they can have access to the presentation, and it's my understanding that that will happen. Is that correct?
That is correct. It will be available on this resource page in the very near future.
And let's just take a few minutes and answer some of these questions because I think some of the questions are fundamental here. One of the questions was, why did the big brokerages settle so fast in this lawsuit? They made an independent business decision that it was easier and quicker and potentially less financially damaging to their business to settle quickly. I think they wanted the certainty and the predictability so that they could just come up with a settlement that they didn't have to go and defend each one of these lawsuits around the country. And I think that's why they made that business decision to settle. I don't think it had anything to do with the fact that they felt that they didn't have strong arguments to make before the judge or even on appeal. And one other question I wanted to address is there was a question about whether the risks and outlook look different for small independent brokerages than large brokerages. This is a really important question. And on one hand, this issue affects each and every realtor. It doesn't matter whether you're a solo practitioner, whether you're part of a small company, whether you're part of a big company. The only reason why the big companies are named and why the small companies and individual brokers are not is because the plaintiff's attorneys feel that the large companies have deeper pockets. The issues themselves affect you just like they affect the bigger companies. And I think in some of these cases, you're starting to see some teams named in the lawsuits, not just the companies themselves, but the teams. So at any point, you could have a plaintiff's attorney name a smaller company or an individual realtor if they felt that it was in their financial best interest to do so.
And then I would just add a clarification to make sure everyone understands when you're handling your compensation or commission language in the blank lines. Of course, that's a company conversation. That's something that firms work with their agents to discuss. When I said that you're not having pre-printed language, I want to make sure it's clear that the companies are making those decisions. It's just making sure that the clients are understanding how the compensation works and how it's paid out. So just a clarification there. I believe we have hit our time unless there is another item that anyone else would like to cover.
No, just a reminder, please ask your questions to the legal hotline. If we weren't able to answer them, we want to be respectful of everybody's time. So that's why we're shortening it to the time allotted. But if you have questions, we will answer them. Please reach out to us and we'll get back to you as quickly as we can. Thank you.
Thank you.